Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University. Today's guest is Richard Katzke, Assistant Clinical Professor of Law and Director of Duke's Appellate Litigation Clinic. A nationally recognized First Amendment and civil rights litigator, he has argued before the U.S. Supreme Court, led legal strategy at Americans United for Separation of Church and State, and served in the Department of Education's Office for Civil Rights. He has also taught constitutional law and ethics at Harvard and American University. Today we're talking about the Free Exercise Clause, and this was always a case that my students loved to get into because then they'd ask, well, why do I have to go to school till I'm 16? So, Professor Katzke, we're looking at Wisconsin versus Yoder from 1972. This case is free exercise. Can you tell me a little bit more about it?
Absolutely. So Yoder is a really interesting case. Until recently, it wasn't actually a terribly important case in our constitutional jurisprudence, and that's just changed, which maybe we'll get into. But here's what was going on. Wisconsin required parents to send their kids to school through the age of 16. That's really common. As far as I know, every state has a similar requirement. It's not always 16 exactly, but the same idea. So Wisconsin had this requirement, and the way that truancy laws work, if you don't send your kids to school, then it is actually a crime for the parents. Now, it's a crime punishable by a $5 fine, I should say, which I'm going to get back to in a minute as well. In a very rural county in Wisconsin, there's a community of Old Order Amish. The people of the Amish faith tend to live for religious reasons the way that a lot of people lived 200 and 300 and 400 years ago. It's an agrarian society. They're farmers. They don't adopt modern technology. They shun a lot of what we think of as modern society, and so they sent their kids to school. They sent their kids to the public schools through about age 14, through the end of 8th grade. Wisconsin requiring through age 16 is about 2 more years of school, give or take, for most kids. These 3 sets of parents, or 3 dads of Old Order Amish kids, sued over not wanting to send their children to those last 1 or 2 years of school. They wanted to have their kids stop at the 8th grade. And then they said, in our community, we instead have, they called it informal education, but they said what we have the kids work with their parents. So as the Supreme Court put it in explaining things, the Amish wanted the boys to learn to be farmers and the girls to learn to be housewives. And so the idea was that instead of those 2 years of school, they would go back and work on the farm. The people who challenged the Wisconsin law in the case argued that making me send my kids to those 2 years of high school interferes with our free exercise of religion in 2 ways. They said, number one, although 2 related ways. They said, number one, kids in high school are experiencing worldly influences that will draw them away from God, from the church, from our beliefs. And number 2 was that as part of our Amish culture, religious culture, you need to be a part of and in this community, not dealing with or turn to outsiders. And so that informal education of learning to be farmers and housewives instead of learning higher math or, more complicated English or things like that is getting in the way of our religious education. So they challenged the imposition of what was a $5 criminal penalty. The families were each fined $5, which, by the way, I looked it up, is about $38.75 today. So that's what the case was about, was just under 39 bucks. And the Amish were arguing that their way of life, the Amish religion and the Amish way of life, is threatened by those requirements for those 2 extra years of school. The Supreme Court, in a decision by then Chief Justice Warren Burger, held that yes, the Amish have a free exercise right to opt their kids out of those last 2 years of school. And the court came to that decision in kind of an interesting way. It spent a lot of time talking about the Amish, the history of the Amish, who the Amish are. And they described this rural agrarian traditional community where the court said there's no record of any crime by any Amish people in Greene County, Wisconsin, and there's no taking of there's no need for public support, and there's none of those sorts of things. This is a responsible, closed community doing its own thing, and doing its own thing in the way that, although the court didn't say exactly this, was basically grandma and grandpa used to do. And so this is a special case, a special situation where the threat to the Amish religion and the threat to these kids being drawn away from their faith, but mostly to the community, the preservation of the community over time, was significant enough that the parents, not the kids, but the parents' free exercise of religion was in danger because of that requirement of 2 extra years of school. And the state of Wisconsin didn't have a good enough reason for requiring those 2 years of school to enforce the law. So the parents are entitled to an exemption from the law.
How should we understand that tension then between parental religious liberty and individual rights or interests of the children involved?
I think this is one of the most interesting questions, and it's one that's beginning to come up in cases today, following on sort of the first times that Yoder is actually being used in cases today. Because the court essentially had an assumption that was they treated the kids' interests as either the same as the parents' interests or not important because it was the parents' religious freedom. And one thing that Justice Douglas, writing in dissent, had to say in Wisconsin against Yoder was, what about the kids who want to go to high school, want a higher education? What about the ones who maybe don't want to stay in the Amish community? They want to have additional life choices that, in addition to being farmers and being housewives. What if they want to be nuclear physicists? How are they going to do that if they can't get an education? The court's view was, the majority's view was, this is a perfectly understandable traditional way of life, and the parents are entitled to protect it because it's a religious way of life. The court said along the way, if it weren't religious, none of this would matter. There wouldn't be a right here, or at least probably not. But because the way of life is rooted in religious beliefs, the parents get to impose that. And so it really set up this deep tension between the kids and the parents. And the court said, well, we don't have any evidence that the kids here, the eighth graders, didn't want to be part of their family's religion, so no problem. What Justice Douglas said in his dissent was, actually, there was a lot of evidence in the trial court that about 30% of the children in the Amish community grow up and leave the community. They're going to go off in other spheres of life. And what about them? And what about their ability to make choices and have those choices? The majority basically said something pretty close to, we don't care about that. We think that the training that they get in being self-sufficient is great and will serve them well, and we don't think that these children want to leave anyway. So it was a funny thing. where the respect for the Amish religion and the Amish culture as a matter of freedom of religion just didn't penetrate to the rights of the students. And that's a tension that we face today.
So Yoder's legacy has evolved as the court has shifted its approach to religious exemptions. How has the case influenced later free exercise jurisprudence? And does that reasoning still hold in today's legal landscape?
So until last summer, we're doing this in December 2025, until the summer of 2025, the answer was it really hadn't made any difference. It was an outlier. The court said along the way, the majority in Yoder said, we looked at the Amish. The Amish are a special case. We're not sure that any other religious group can actually make the showing that they did about the threat to their religious community, and that they're all good law-abiding citizens who aren't on the public dole, as the English would say, aren't getting taking government benefits. It's not costing the rest of us anything, so they should be able to do their thing. The court basically said, we don't know that anybody else can ever make that showing. So lots of people have held up Yoder over time as this real almost centerpiece of the idea of parental rights and parental control. But the lower courts didn't think that that was right. What happened last summer, the Supreme Court decided a case called Mahmoud against Taylor, which was a challenge to a part of the curriculum in Montgomery County, Maryland's public schools, involving storybooks for elementary school kids that had LGBTQ characters. And some parents brought a challenge to that curriculum, saying that they have a free exercise right not to have their kids exposed to anything that's a threat to, depending on what they said, the parents said either their religion or their kids' religion or their ability to teach their kids their religion. And they invoked Wisconsin against Yoder. The Supreme Court decided the case after and a number of other cases saying Yoder was special, Yoder was about the Amish. The Supreme Court now said, no, Yoder is, like all our other cases, a big statement of principle that applies broadly. And this means that parents get to opt their children out of lessons, storybooks that the parents see as a threat. That's the word that the court used, a threat to the parents' religion or ability to inculcate their religion in their kids. Yoder is now a really important decision that we have to sort out what it means for schools because of that decision.
Yeah, and that just adds to the complication. Professor Katsky, again, thank you so much for your expertise on Wisconsin versus Yoder and the free exercise clause.
Oh, absolutely. Great fun to do it.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.